So thank you all for coming, and thank you very much to Lady Hale for taking the time to come from London to visit us. And I believe it was a rather dramatic journey that involved stopping in such exotic places as Leamington Spa. All I'm going to do is to say welcome, and thank you very much for coming, Lady Hale. And I'm now going to hand over in a rather complex chain of authority to Alex Villiers, who's going to say a few words, and then he will hand over to the Master and Mistress of the Moot. Thank you.
Hi everyone. It's absolutely amazing to see so many people here today, and I'm quite sure that that's down to our guests. It's an absolute honour to have Lady Hale here today. Just a few quick thank yous. First of all, thank you to our sponsor, Clifford Chance, because this would not have been possible without them, obviously. I just want to say that the standard in the mooting competition this year has been phenomenal. I was lucky enough to judge a few of the moots, and the standard really was exceptional. So massive congratulations on getting the start. Also, we must take note of the hard work done by the subcommittee, the mooting subcommittee. Again, fantastic work by all of them. But last but not least, a massive thank you to Ali and Ryan, who've been absolutely fantastic this year in organising the competition. I won't talk any longer because I know everyone's really eager to start. So I'll hand over to Ali and Ryan.
Right. Welcome everyone to the final of the internal mooting competition 2013. As Villa's already mentioned, we'd like to extend a few thank yous. First of all, to Clifford Chance for sponsoring the competition. Second of all, to Warwick Law School for kindly providing the drink reception at the event.
There's a little more to say, but I think we owe a special thank you to Professor John Snake for his continuing commitment and help throughout the competition. He's helped us out of a few very, very sticky situations. This particular moot problem is unique. It's very long. I've never seen a problem on restrictive covenants. So I think it's very appropriate that we have the utmost pleasure of welcoming Lady Hale from the Supreme Court here to judge the final. So without further ado, I wish the finalists the best of luck.
May it please your ladyship, my name is George Kassimos, and I appear in this case with my learned junior, Melissa Maynard. We appear on behalf of the trustees of the foundation. My learned friends, Mr. Clemence and Mr. Marc Malone, appear on behalf of the respondents. Before contending the grounds of the appeal, would your ladyship appreciate a brief acquaintance with the facts?
I believe that I am thoroughly familiar with the facts. However, I'm not sure that everybody in the room might be. Would you like just to outline them? That won't come off your time, I'm sure. Sure.
In 1932, the vendors of the foundation's land, namely Sir Reginald Smallpiece, Brigadier Horatio Carberry, and Lord Alfred Charcoal, sold this piece of land to the East Barsetshire Developments Ltd, the company. Between them, they created a restrictive covenant which was not registered anywhere because the company's solicitors saw it as unnecessary. The company then unfortunately went bust prior to any development and was conveyed to the liquidators. In 1934, Mr. Grimshaw acquired the foundation's land for £1,000, and in 1938 sold this land for £1,500 to the Barset Health Foundation, established in 1907 for the advancement of health and the treatment of those suffering from AIDS and HIV, but also for the research into treatment of the virus.
I feel quite sure that they weren't established in London, whenever it was, for the treatment of those suffering from AIDS and HIV.
Well,
that seems a little premature.
Yes, yes. They also provided a hospice for the terminally ill, and this land, when it was purchased in 1938, came under compulsory registration. However, unfortunately, due to wartime restraints and financial difficulties, the foundation did not develop this land. However, in 2011, they decided to start building and then applied for planning permission, which was granted in January of the same year. Further, the foundation then sought a declaration from the court that the foundation foundation's land was not burdened by the covenant and thus the restriction. And secondly, that in any event, none of the respondents or who they represent do not have the benefit of the covenant. This permission, unfortunately, was not granted, and it was found in a short judgment at the Court of First Instance and then in the Court of Appeal that even though the respondents could not produce a map or plan identifying all the benefiting land, that one, the foundation's land was in fact burdened by the covenant and thus the restriction, and that this was because there was a notice on the registered title of the foundation's land, and two, that all the respondents had the benefit of the covenant annexed to them expressly or alternatively through the operation of statute.
And you're going to try and persuade me that nobody has the benefit of this covenant.
Well, I will be contending the first round, which is that because there was no notice of the covenant, it didn't bind the foundation's land. And my learned partner, my learned junior, Melissa Maynard, will be contending the second round of appeal. Now, with regard to the first round of appeal, I have three submissions to make. Firstly, the notice on the Charters Register does not prove that the covenant is valid, and consequently, it is not necessarily protected. Secondly, that during the 1932 conveyance, there was a failure to register the covenant as a D2 land charge in the Register of Land Charges, and therefore it became void when Mr. Grimshaw purchased the land in 1934. And thirdly, as a matter of public interest, the restriction should be discharged.
Yes. However,
yes.
Under what provision do you seek to argue the third point?
Under section 84, subsection 1(1) of the Law of Property Act 1925,
And where will I find
and
that?
you'll find that in section 5, tab 60, no, sorry, section 5, tab, section 5, tab 8 of the bundle, I'm sorry.
Yes, that sounds right. So it's under section 84,
Subsection 1AA, sorry.
1A, 1A,
Yes, it is highlighted, 1AA, yeah.
yes. And where do you bring proceedings under that section?
To the Supreme Court,
Where do you bring proceedings under that section?
to the upper tribunal, the court of the upper tribunal.
The upper tribunal.
Yes.
You didn't bring proceedings in the upper tribunal, did you, Mr. Kassimos?
Uh,
You brought proceedings in the High Court.
Yes, and unfortunately, we did not bring proceedings to the upper tribunal. However, my lady, we submit that the upper tribunal does hear appeals from the lower tribunals on questions of law.
But it doesn't. The High Court does not have jurisdiction under section 84, subsection 1. You
Yes,
were in the High Court.
yes, we submit that because they make judgments on points of law, that this Supreme Court has the power to.
With respect,
Yeah.
you have to start your proceedings in the right place before you can give us jurisdiction to hear an appeal against proceedings you didn't bring.
And unfortunately, my lady, we did not bring, and we apologise.
There's no need for you to apologise to me.
Yes,
You should be apologising to the people sitting behind you.
I apologise.
I mean, that's your day job.
Yes.
So, does that mean that point 3 of your argument really falls away?
Yes.
Perhaps then we'd like to concentrate on points 1 and 2.
Yes. Yes. Okay. Now, my lady, the first ground, the first submission that the notice on the Charters Register does not prove that the covenant is valid can be seen in section 32, subsection 3 of the Land Registration Act, found in section 1, tab 1 of the bundle. My lady, it the notice on the registered title in the Charges Register is conclusive so far as notice is concerned, but we submit
I need to find it first.
Oh, sorry.
Where is it?
It's on section 1. Section 1. No.
Section 1 has section 32.
Yes.
Section 32 is the one that you're...
Yes, section 32, subsection 3.
Yes. That is authority for your proposition that the mere appearance of something on the register doesn't mean that it's valid. Yes.
Yes. And we submit that because even if there is notice, this notice was placed there due to the compulsory registration in 1938, and however, we will submit in my second submission that the covenant was void in 1934 when Mr. Grimshaw purchased this land.
So when will the covenant have gone on the register in 1938? Will it have gone on before or after your clients purchased the land?
At the point of purchase.
Before or after?
After it was purchased. My lady, we submit that any type of registration during the 1932 conveyance between the vendors and the conveyance and the company, that the burden was not conveyed to Mr. Grimshaw. This was because Mr. Grimshaw purchased the land without any notice in 1934. The Land Charges Act 1925, now consolidated by the Land Charges Act 1972, introduced the element of certainty into the transfer of interest affecting unregistered land. This has been done by only recognising notice when it is formally registered.
Where do I find that?
You'll find that in section 4, subsection 6 of the bundle, which is section 3, tab 3.
There's always something. Section 4, subsection 6 of the bundle.
Yes.
At the Land Charges Act 1972, two bits thereof in section 2. At the Land Charges Act 1925, which is what we're referring to, tab 3. Is that what you're referring to? Which act are you referring to?
Yes, the Land Charges Act 1925, which is found in section 3 of the bundle, tab 3.
Yes, I have found it now.
Okay.
Thank you.
The Act specifies that restrictive covenants that aren't duly registered before the purchase and are purchased by a purchaser for money or money's worth, they are rendered void.
Where do I find that? In which section do I find that?
Section 4, no, sorry, section 10, no, sorry, section 4, subsection 6 of the Land Charges Act.
We don't have section 4, subsection 6.
Of the Land Charges Act 1972.
I'm looking at the Land Charges Act 1925, which I believe is the act that was in force when the conveyance in question took place.
Yes, well then you can look in section 3, section 13, which is found in the same section.
Yes, I have that.
Yes, there, as I submitted prior, your lordship, your ladyship, that sorry.
People get dirty looks from you. They do that in court. So this is why you should be exempt.
Yes.
Subsection
Subsection 2.
of the Land Charges Act 1925 provides that.
That a restrictive covenant is void for non-registration when one, and in this case Mr. Grimshaw, purchases the land for money or money's worth. And we submit that Mr. Grimshaw did purchase the land for money or money's worth, and he had no notice of such a covenant. And thus we submit that it should not be, it should not burden the foundation's land.
And what about the foundation?
The
Were they a purchaser of
they actually purchased the land for £1,500, and we submit that once a restrictive covenant is void, it cannot be revived.
Well, that would be an interesting point of law.
Yes.
If your clients have been donees of the land, rather than purchasers for money or money's worth, would the fact that it had become void as against Mr. Grimshaw, who sold it to them, mean that it was also void as against them? You don't have to answer that question because it doesn't arise.
Yes.
But that would have been an interesting question. So, you say it's open and shut case.
Pardon? Yes.
You say this covenant ought to have been registered by virtue of Section 13 of the Land Charters Act 1955, which was legislation coming into the time. It wasn't. And therefore it's void, not only as against Mr. Grimshaw, but as against your client.
Yes.
End of story. Is that your case?
Yes, that is the first round of our appeal.
Is there anything else you need to say?
No, in terms of my the first round of appeal, I have no more submissions to make my appeal.
Are there any more submissions you'd like to make?
In this present case, we would like...
You can take instructions
Yes,
from your
that's what I'm doing.
Passing notes from juniors to leaders is very common.
My lady would submit that on grounds of policy, this restriction should be discharged because the creation of a hospital or hospice, and in this case a research facility looking into...
That's your third group.
Yes.
That's a jurisdiction I do not have.
We are disregarding...
I'm not.
Well...
First message to learn in any court is make sure the court's got power to entertain the argument you're making.
Yes, but we feel that the Supreme Court must take into account some policy considerations.
The Supreme Court applies the law.
Yes.
If the law is clear, that is the end of the matter. Your learned opponent is going to have to persuade me that it's not the end of the matter. And if he has got a good argument that it's not the end of the matter, you have a right to reply.
Yes.
I suggest we sit down. Miss Maynard, do you wish to follow?
Please, your ladyship. My name is Melissa
I
Maynard.
know your name. I've already been told it. You don't need to say it again.
I'm here, as I'm sure you already know, for the appellant on the second round of appeal. And the second round is that all respondents and those who they represent do not have the benefit of the restrictive covenant in question because it was not expressly annexed to them, the vendor's retained land, and neither was it annexed by statute to the retained land. I have three submissions to make with regards to this round of appeal. My first submission is that in order for express annexation to occur, the land intended to be benefited must be identified within the covenant. In the present case, no benefiting land is identified, so therefore there cannot be express annexation of the covenant to the land.
Well, that's an interesting submission, isn't it? I'm sure it will be said against you, but it is quite clear from the proviso to the covenant, which reserves certain rights to the vendors, to do various things. It is for the clearly for the benefit of adjoining or adjacent or other property of the vendors.
Yes.
Can it not be deduced from that this benefit of the restrictive covenant, to which this is a proviso, was intended for the benefit of adjoining or adjacent or other property of the vendors?
No, it cannot because I'm afraid, your ladyship, that that land, the adjoining and adjacent property, is in no way ascertainable in anything contained in the conveyance. May I refer your ladyship to Plan A, which
You
can
may
be
refer me
found
to Plan A.
on,
Yes.
I think it's the Roman numerals tab.
Well, I have it in my own papers, yes. But thank you.
Plan A was the only plan containing the conveyance in addition to the mention of adjoining and adjacent land. As I'm sure your ladyship can see, Plan A is not detailed. It shows no clear depiction of the said adjoining and adjacent land. In addition, if I could refer your ladyship to paragraph 15 of the appellant's instructions.
No. You would never do that in court. Your instructions are private as between you and your client. You would never do that. Now, what is it? I will, of course, look.
Problem, I apologise, your ladyship, it wouldn't happen like that in the Supreme Court.
This bears no resemblance at all to what would happen. Including the number of interventions that I'm making. But that is for your benefit. Now, you could say that you are instructed that the foundation solicitors have found it impossible, despite extensive research, to establish the precise location for extended Deepdale Farm, of which this land formed part in 1932. However, you must concede that Acacia Avenue, on which two of the respondents live, must have been adjoining or adjacent land.
Yes, it's difficult to say that it is not. However, that is not the requirement for express annexation to occur. The requirement is that all the land must be reasonably ascertainable and defined, not just some of it. Because
Where did you get that proposition from? What's your authority for that proposition?
it's just the law on restrictive covenants.
What's the authority for the proposition? The whole of the law of restrictive covenants, say that which is contained in statute, is contained in decisions of the courts.
It is Reynolds and Cowlishaw reported in the reports in all the courts for 1876. It can be found in section 6, tab 9 of the bundle.
I'm finding your tabbing very difficult. That's not your fault, no doubt.
Apologise.
Reynolds and Cowlishaw, yes. It's about as common an express indication as can be found in conveyances that it's for the benefit of adjoining or adjacent land of the vendors. So, what are you getting out of this? What is the bit you want to draw my attention? To enable an assigned to take the benefit of restrictive covenants, there must be something in the deed to define the property for the benefit of which they were entered into. Yes?
Yes, and therefore I would submit that that ought to be read, that there must be something to define whole land. It is well known that in property law and the law of land, certainty is an absolutely fundamental principle, and therefore to say that only some of the land need be reasonably defined would take away certainty, because it would no one would know where to stop when someone is purchasing land. A purchaser would not know who has the benefit of a restrictive covenant. That were to be decided in this case, that only some of the land ought to be defined.
What about adjoining or adjacent? Is that pretty clear?
Well, yes, it is, your ladyship. However, I would submit that it needs to be the whole land defined, not just a small portion adjoining and adjacent, because since the 1932 conveyance was made, the area has been changed completely. It was not in 1932 intended for Acacia Avenue, because Acacia Avenue didn't exist in 1932. It is, I believe, post-war housing, so therefore it cannot be intended by its very nature for Acacia Avenue and those residents.
You don't deny that Acacia Avenue at that stage, and the land on which Acacia Avenue stood, was both owned by the vendors at the time and is adjacent or adjoining to the land in question.
It is adjacent and adjoining, and I would submit that it virtually certainly was owned by the vendors at the time. However, that I would not suggest that that is completely certain, as no one can ascertain where the exact land, i.e. Deepdale Farm, that the vendors did retain.
Well, they may not be able to ascertain the whole of it, so if you are right on that proposition, for which you have cited no authority whatsoever, I might be with you. What about the other two respondents? Well, was Acacia Avenue? One of them is a mile away, and the other is half a mile away. Now, are they covered by other land of the vendors?
purchased in 1930 from the vendors, and that is before the restrictive covenant existed.
Yes, he's going to have a big problem convincing me that he has the benefit of a covenant that didn't exist when his predecessor entitled bought the land.
So essentially, by the very
I'm
name.
saying that for the benefit of the land. What about number 3? What about the other one, the fourth one?
The only land that can be ascertained as belonging to the vendors is to the north of the Foundation's land, and Mr. Bly lives a mile to the south of the Foundation's land. So, for that reason, there is nothing to suggest that that was part of the land intended to be benefited, because it's not shown at all on the conveyance plan or Plan A or the conveyance. It's not adjoining and adjacent.
Plan A benefited those who are behind you. Contains a plot of the land that is conveyed, and it also says, to the north of that plot, the Marquis of Barsetshire settled estate, from which one can deduce that the Marquis of Barsetshire settled estate included the land to the north of the plot. It isn't so described to the south of the plot. However, the plot in question was actually conveyed by the same trustee, was it not?
Yes, it was. But the only mention of land in the covenant that we are discussing presently was adjoining and adjacent, so therefore...
And I did also cite to you, it says other land of the vendor.
I would submit
Is this other land of the vendor?
where it says other land vendors is in the proviso, and the proviso is largely for the benefit of the vendors.
How true.
Pertain,
That's what we're discussing. What's for the benefit of the vendors?
but it does not, it is nothing to do with the restriction, so therefore the restriction cannot be affected by that passage, because it is essentially giving rights to the vendors to dispose of any further land without any need to be burdened by the restriction. So therefore it's not relevant to the case in question at the moment, because essentially we need to remove the restriction from the Foundation's land.
You need to. That's your case. But unfortunately, you have opponents who need the restriction to be maintained. Have you completed your submission? Is there anything else you'd like to say?
No, there is not. That completes my submission to the issue.
Thank you very much indeed. Thank you. Yes.
May it please your ladyship, my name is Mr. Clemence, and I appear in this case with my learned junior, Mr. Malone, on behalf of the respondents. Regarding the first ground of appeal, I have 3 submissions to make. First, that the burden of restrictive covenants can run in equity, so long as several criteria are met. I respectfully submit that these requirements have been met in this present case. Second, that the destruction of a proprietary right due to a mere formalistic technicality is an interference. I'm sorry, my lady.
I've never heard the registration of land charges described as a mere formalistic technicality. You must be congratulated, Mr.
As I was saying, my lady, this is an interference with an individual's entitlement to the peaceful enjoyment of his property, and I would respectfully invite the court to adopt a liberal interpretation of the Land Charges Act, thereby respecting the will of Parliament as evidenced by the Human Rights Act.
And when did the Human Rights Act come into force?
1998, my lady.
No.
Sorry, my lady. It came into force in 2000, October 2000.
And when did the conveyance with which we're concerned take place?
The conveyance took place in 1938, my lady.
And when was the European Convention on Human Rights adopted?
I believe it was in the 1950s, my lady.
When was it ratified by the United Kingdom? No matter, you're right about the 1950s. Well, 1950s. So when did the rights and
become part of the law in the United Kingdom once the Human Rights Act came in force. But
Does it have retrospective effect?
Yes, my lady. The Human Rights Act, Section 3 obligation to interpret legislation in a manner which is in coherence with the European Convention on Human Rights applies to both legislation that is before the Human Rights Act as well as after the Human Rights Act.
It does, but does it apply to the events that took place before the convention even existed?
My lady, I respectfully agree with your point that it is not sure whether it applies to events that occur before, and that the better view might be that it does not. However, I would still have to persuade my lady that you should take this into account when deciding this case.
Well, I've heard your submission. Have you come across a case called rebuttal?
I'm afraid I have to say no, my lady.
That is a case in which it was held in the House of Lords that the Human Rights Act does not apply to a death taking place before the Human Rights Act came into force. It's a little bit difficult, isn't it, to argue that a property right, which was interfered with on your case in 1938, is covered by the Human Rights Act?
That is true, my lady. I admit I concede the strength of your arguments. However,
It's not my argument. That's very sensible of you.
thank you, my lady.
Could you therefore, I'm doing exactly the same to you as I did to your learned opponent, you may have noticed. That is rubbishing one of your arguments. Could we concentrate on the first one? On which you're...
Yes, my lady.
What's your answer to the Land Charges Act?
My lady, in terms of notice which has been replaced by registration within the Land Charges Act, I would like to make two different submissions. First is that the purchaser, which is a foundation in this present case, must have been given notice. When title is registered, a restrictive covenant may be protected by means of an agreed notice in the Charges Register. In the present case, paragraph 13 of the instructions which I have received, which I know I cannot refer my lady to, show that such an entry has been made. The first registration...
It's common ground that there was an entry on the register when the land was first registered. The difficulty is the land was first registered after the conveyance to your opponents.
Sorry, my lady, if you could repeat the last point.
Well, it's pretty fundamental. They bought the land was conveyed, it was then registered.
Yes, my lady.
Title was registered.
And I would argue, my lady, that if you take into account the policy justifications of a registration statute.
Yes, the policy justifications of a registration statute is that people shouldn't commit themselves to spending large sums of money, and I'm sure you will agree that in the 1930s the sum of money that was spent on this land was large, without having notice of firms that go with the land.
Yes, my lady. I would argue that, however, that the mere principle is a key feature of our modern registration system, and therefore, if it was found in the Charges Register of the registered title when the foundation took over the land.
This is first registration. The registration would have taken place as a result of and following the conveyance to them.
Yes, my lady. And if I could refer my ladyship to, if I could refer your ladyship to tab 5 of our binder.
By all means.
My lady will be able to see the Land Registration Act 2002. And I'll refer your ladyship to section 34, subsection 3, which shows the requirements of an agreed notice for such a notice to have been entered into the Charges Register. As you can see, the foundation must have consented for an agreed notice to have taken place. Alternatively, entry into the Charges Register could have been made by way of a unilateral notice, which can be found at section 35 of the same Act. In such a unilateral notice, the foundation would have been given a notice of the entry, since the land registrar would be under duty to give notice, and chose not to apply for the removal of the entry, thereby indicating their implicit consent.
Section 35. And this is in the Land Registration Act 2002.
Yes, my lady.
And what is the retrospective effect of that legislation?
My lady, the reason I cited the Land Registration Act 2002 is because it replicated substantive provisions found within the Land Registration Act 1925.
And which ones does it replicate?
Unfortunately, my lady, the sections in question are not included inside the binder, and therefore I'll be unable to refer you to those sections.
So you haven't looked at the transitional provisions of the 2002 Act, and you haven't looked at what it replicates in the 1925 Act, which is the Act that was current at the time of the conveyance that you're concerned.
Yes, my lady.
Thank you. And have we any evidence that they notice was given?
Sorry,
Have
my
we
lady.
any evidence that a registrar's notice was given to the proprietor of registered estate?
No, my lady, but it would seem highly unlikely that actual notice was not given by the registrar to the foundation.
Seems highly unlikely to me that the registrar was following the proper procedure, as he noted this charge on the register when it was void.
And my lady, I respectfully submit that even if it was not, they were not duly notified, proper investigation of the title of the land for the previous 15 years, as they are required to do so, would have found such a restrictive covenant located in the deeds.
But it would also have found, would it not, that the restrictive covenant contained in the conveyance to the company had not been registered and was therefore void as against Mr. Grimshaw. A proper search would have been done, would it not?
Yes, my lady.
Your point on section 35 is a much more interesting point than the section that says that. But you don't have the evidence to back it up.
On the facts of the case, it could go either way, my lady. Whether or not they actually have actual notice, since it's not actually indicated by the instructions I received from the previous counsel representing my clients.
Ah, well done. Yes, thank you very much.
I would also like to respectfully submit, my lady, that in section 29 of the Land Registration Act 2002, which is found at the same tab, which is tab 5,
Yes.
the foundation's land now falls under the law governing registered title. An interpretation of section 29 is that it does not cause an unprotected right to be void as an interest against the land, but merely as the section says, postpones it. The interest continues to exist as a property right. Clearly, this is perfectly proper and illustrates why section 29 is expressed in terms of priority rather than voidness. An unprotected interest survives a registered disposition, as it were in suspense, so that they will enjoy priority against a subsequent transaction. Where X is an unregistered restrictive covenant against A's land and A sells to Mr. Grimshaw, I would submit that X could register after the sale to Mr. Grimshaw in order to bind any future purchaser, such as the foundation. On a literal reading of this section, my lady, this would seem possible. The covenant merely has lost its priority against Mr. Grimshaw, but still survives as a property right.
Yes, thank you very much. Thank you.
Thank you, my lady. My final submission, if you'll be interested to hear it, is...
I'll always be interested to hear your submissions.
That's most kind, my lady.
Maybe in the interest of your clients that you make them.
Which is that the foundation can nevertheless be treated as a direct party to the covenant through the 1938 conveyance itself.
Do we have a copy of the 1938 complaint?
Unfortunately, that was not provided.
So we don't. More evidential points that you've got a problem with, isn't it?
Yes, my lady.
Yes, right, so that's good.
If my lady would accept that it was inside the conveyance itself, because if
I'm
not,
not going to accept.
if not, it would seem improbable, my lady, that such a restrictive covenant was entered into the charges register. It must have come from somewhere. I'm aware that it's a bit of a stretch, my lady.
Well, no counsel ever lost a
continue in saying that by completing the transaction, the foundation has agreed to the terms of the conveyance, which included the terms of the restrictive
But we
covenant.
don't know that, do we?
No, we don't. If my lady will make a finding to that effect, though,
I'm not making any finding. You have no evidence.
in that case, Your Ladyship, as you have clearly pointed out the evidential difficulty that my client faces in this present case, I would respectfully submit that if Your Ladyship has no further queries, I will conclude my submissions and thank the court for your time and urge that this appeal be dismissed.
Bold submission.
Please, Your Ladyship. I appeal for the respondents in the second round of appeal. In relation to this round of appeal, I have two main submissions to make. Firstly, the respondents and those who they represent have the benefit of the covenant because the benefit was expressly annexed to the lender's retained land. Secondly, in the alternative, the benefit of the covenant was annexed to the lender's retained land by operation of Section 78 of the Law of Property Act 1925. As such, the respondents and those who they represent have the benefit of the covenant. Moving on to my first submission, my lady. As is already established, annexation is the process by which the benefit restrictive covenant is metaphorically nailed to the land, such that the benefit subsequently passes with any transfer of the land. This may be done so by clear verbal formula, and I would refer Your Ladyship to the case of Rogers and Cosgood, reported in the second volume of Law Reports, Chancery Division for 1900, and found in the bundle at tab 11. I would draw Your Ladyship's attention to page 395, which is located by a blue tab. It was stated there, covenants which run with land must have the following characteristics. 1. They must be made with the covenantee, who has an interest in the land which they refer. 2. They must concern or touch land. Subsequently, at page 396, it was said that the covenant may have two characteristics above mentioned and yet not run with land. It is in each case a question of intention to be determined by the court on the construction of the particular document and with due regard to the nature of the covenant and the surrounding circumstances.
Yes. It's common ground that this is the sort of covenant that can run with land.
Gratitude, my lady.
The problem is, what land, if any, does it run with?
On the facts of the case, would you like me to explain whether or not the first two criteria are met as well?
Nope.
Okay.
That was not the issue.
The
The issue is whether all of your clients, any or all of your clients, are entitled to benefit of this covenant.
Understood, my lady.
And one point that's made against you is that only to identify the benefit of the compendious provision of the conveyance by reference to a proviso to the restriction doesn't expressly and clearly identify the land to be benefited. That, as I understand it, was Miss Maynard's submission against you.
My lady, I would submit that in addition to the proviso provided in the covenant, there is a reference in the restriction to a purpose which may tend to depreciate the value of the vendor's adjoining or adjacent property. I would submit this is indicative of a touching and concerning of land, as it affects the value of land, and it's not meant to bind personally.
Covenants with the vendors and their successors entitled, but that's not much help, is it?
My lady, at paragraph 15, I apologize.
I'm just reading we would have the terms of this restrictive covenant in our papers, I can assure you.
It is understood
The
that.
fact that they happen to be contained in privileged documents is neither here nor there for this purpose. We would know what is there. But which bit of the provisions in question do you say annexes this covenant to the land owned, as I say, by any or all of your clients?
schedule of restrictive covenants the restriction which provides as follows. 1. That no house or other building erection or structure
Yeah, you
erected,
don't need to read that.
etc.
Yes, yeah. It contains a hospital, which is the important point.
Understood. And towards the end it says, or which may tend to depreciate or lessen the value of the vendor's adjoining or adjacent property.
Yes. So, you say it's clearly for the benefit of the vendors adjoining or adjacent property,
That is correct, my lady.
especially when you read it with the proviso.
And especially with early on where it talks about the vendors and their successors in title. Read together, it is my submission that it was meant to benefit the retained land of the vendors and the adjoining and adjacent property.
You'd better start differentiating between your clients.
Gratitude, my lady. I will do so right now. And it is understood that there are three main classifications of clients. In this case, Acacia Avenue is clearly part of the retained land to be benefited. It is clearly reflected in Plan A, which is noted to be a copy of the 1932 conveyance plan. And Acacia Avenue is clearly hatched as being adjacent and adjoining to the foundation's land. The facts and the plan raise no doubt or dispute that it is north of the foundation's land and was once part of Deepdale Farm, which was the land retained by vendor. In particular, 25 Acacia Avenue is clearly noted to face the foundation's land, and if the new facility is erected, it will face its main entrance.
Well, assume for the moment that I might be sympathetic to that argument. Move on to the other two.
Gratitude, my lady. In relation to the other representative defendants joined to this case, my learned friends have established that Mr. Newell's house at 117 Green Lane was conveyed in 1930, and thus 2 years before the conveyance, and such the benefit of the covenant cannot be held to annex to its land.
And what do you think of that? Have you got an answer to that?
I would submit that as he is a representative defendant, as long as South Sea Avenue, owned by Mr. Bligh, which was conveyed in 1942, is representative of the other defendants, and if it can be proved that his land is annexed either by way of statute or by way of express annexation, then the respondents will have the benefit of the covenant.
Representative defendant is representing a whole range of people who have the benefit.
That is correct, my lady.
Is that not correct?
It is my submission
But
that
surely you're asking for a declaration that would include the third respondent.
my lady, I am respectfully seeking a declaration that of the people in those two properties, or as they say land, for those who have obtained property after the 1932 conveyance, it is my submission that they obtain the benefit of the covenant.
So you're not really submitting to the third respondent.
Not the third respondent.
Well, the plot which belongs to the third respondent is the benefit of the covenant.
That is correct.
Well riddled. And what about the fourth respondent?
Fourth respondent, South Sea Avenue, owned by Mr. Bligh, is noted to be located about a half mile from the foundation's land to the south. It is submitted that, in this case, additional extrinsic evidence can be obtained by way of research in order to establish whether or not Mr. Bligh, obtains the benefit of the covenant.
But we're in the Supreme Court. You can't get extra evidence before an appellate court if you could, by reasonable research, have got it before the trial judge.
My lady,
It's not introducing new evidence.
I would respectfully submit that I am not introducing new evidence. It's been established that through research beforehand that South Sea Avenue was indeed once caught or once owned by the vendor's property.
That
That
has
is-
been established.
That was the evidence I was trying to submit. I apologize.
That has been established.
I apologize for the
Yeah.
misunderstanding.
But has it been established? Well, you would agree that it's not adjoining or adjacent. Don't you? Wouldn't you?
I would submit that because the land was once owned by the vendors, coupled with the fact that the vendors had sold off parcels of development for residential use after 1932, should give sufficient notice to the vendors or to the purchasers and suggest that there is a possibility that they were at one point adjacent to the foundation's land. I understand it is a matter of fact and degree, and I would respectfully submit that this will be for the court to decide.
Which court?
A trial court which determines facts.
And what did the trial court